Welcome everybody to this, I think this is our fourth live newsletter for clients of Brodie Jackson Cantor and the COVID-19 Families for Justice group. And tonight's session is on the Gardner case, on how care homes were handled during the pandemic and the listening project. So our aim in this and previous live webinars has been and is to help our clients and members of the COVID-19 Families for Justice group basically to get to grips with where they stand in the ongoing legal process. This evening's live newsletter is going to last no longer than an hour as per usual, but this time, a bit different to last time, we've split into two sessions. So in the first session, Oliver Lewis, who's a member of our counsel team, is going to be discussing the outcome and the implications of the Gardner case. And this was the case brought by, amongst others, Dr Cathy Gardner. It looked into the government's various policies for care homes and the implications that those policies held for the care home residents and staff. And when Oliver has finished his analysis of that, we're very lucky actually to have Dr Cathy Gardner, Cathy, one of the two claimants in that case with us tonight. And she's going to be offering her thoughts on the unfinished business of the case. Then we're going to swiftly move on to a second session in which Elkan, our lead solicitor at Brodie Jackson Cantor, and Pete Weatherby, the lead QC of our counsel team, are going to talk about the listening project. And that was an initiative that was announced by Baroness Hallett on the UK COVID-19 inquiry website on the 8th of April. And those guys, they're going to be seeking your views basically on what proposal we should make to Lady Hallett regarding the material that she should hear about in the lives of your loved ones, and separately the circumstances which led to their deaths subsequent to the advice which we circulated recently. So basically this webinar is being held to offer you, our delegates, insight into and our analysis on the Gardner case and that listening project. So for those of you that haven't been on these before, I just want to introduce the live newsletter format very quickly, as there will be people who haven't attended previous sessions. And I just want to explain that the team at Brodie Jackson Cantor were already sending clients who've asked us to represent them regular email updates. And this session is simply a live version of those, really, run in a format that's designed to allow your legal team to update you directly on what's happening in an easy to digest format. A few words on questions and comments. So unlike previous sessions, due to the amount of material that we've got to get through this evening, our panel aren't planning on taking live questions during this hour. However, if you have questions on anything that you hear tonight, please do put them in the questions and answers section that you should see in the webinar's navigation on your screen. As per usual, these questions will all be answered by our team in the few days following the webinar. And also the questions and answers to this session will be published on our website as the Q&As to all the previous sessions have been. And that's a really valuable resource for you guys. If there's questions that you want to ask, please do have a look at the Brodie Jackson Cantor website, and I'll dig out a link for that and stick it up there as we go through in the comments. Just to reassure you, anything that you ask, all the questions are anonymous, so please don't be shy about making a query. And then a really quick word on comments in the chat. We've had a few comments on opinions voiced in the chat in previous webinars. We just wanted to say really that as a team, we feel the chat is a really important reflection of the views of a broad church of stakeholders in this. That includes you, our clients, and members of the COVID-19 Families for Justice group. We're not really inclined to moderate the chat, as everybody has an opinion, and whilst details may differ, and I mean inevitably they will with 100 people on things like this, we're all pretty much after the same thing. So I'd simply ask you to respect that thought as you participate in the chat. Thanks. So now, Elkan, do you mind just introducing the panel for tonight's session for me, please?
Yeah, and just before I start, I see someone's made a comment saying the audio is playing the vocal twice. If that might just be a problem at their end, but if anyone else is experiencing that problem, can you mention it in the chat and we'll see if it's a problem at our end. Yeah. So for the first half of the session, we're blessed to have two doctors, three if you count my honorary PhD, which I don't, Dr. Oliver Lewis, who is a specialist in healthcare, and Dr. Gardner, who, as Andrew has said, is one of the litigants in the Gardner case. So it will be very helpful for us to have the perspective of a barrister, but also of a litigant, to see what she thought of the case and what she thought of the way the case was handled as well. So if I can pass over to Oliver before we get to part 2. Thanks, Oliver.
Thanks very much. Good evening, ladies and gentlemen. I'm just going to try and share my screen. I think
I'm just going to make you the host, Oliver. So there you go. I've just made you the host.
Thank you.
There you
go. Right. So hopefully hopefully you can see that. Can you just confirm that you can see the full?
Yeah, we can see that.
Brilliant. Thank you very much. Right. So I'm going to be talking about the case in which Cathy, if it's okay, Cathy, to use first name terms, was one of the claimants. And I've put in the chat the link to the judgment. It's an incredibly long judgment. It's 75 pages. And in my presentation, in square brackets, I've put in the paragraph numbers so you can kind of tally the two up. So the health warning at the beginning is that I can only really scratch the surface of the judgment. It's a very detailed judgment in the time that I have, and indeed the time that Cathy has. It's worth reading in full. The court also produced a sort of executive summary of the judgment as well. So this is it. It is a judgment of the administrative court, which is one of the sort of branches, if you like, of the High Court, and is the place where people go to, among other things, to say that their human rights were breached and to take a judicial review. So this was published at the end of April, and you can see there who the claimants were, Cathy Gardner and Faye Harris, and you can see that the defendants were, at the time, Matt Hancock, so Secretary of State for Health and Social Care, as well as NHS England and Public Health England. But the case sort of focused on the first defendant, so what the government did, Matt Hancock. So briefly, what were the facts of the case? Well, as you all know, very tragically and horrifically, and we don't know the exact number, but around 20,000 residents of care homes just in England died of COVID during the first wave in the early mid part of 2020. And this case concerned two particular people who died. So Michael Gibson, who was Cathy's father, sadly died on the 3rd of April 2020. And Miss Faye Harris's father was called Donald Harris, died on the 1st of May 2020, both in care homes. And Cathy and Faye, the claimants, went to court not for money. They didn't ask for compensation, but they asked for what we call a declaration, which is just a statement from the court to say that something was unlawful. So they asked the court for a declaration that the policy document, so the overall policy framework of the government and NHS England, breached their father's right to life under Article 2 of the European Convention on Human Rights, and Article 8, their right to privacy and home, or were otherwise unlawful under common law, in which decisions by state bodies should be reasonable and rational. So that's what they asked for. The High Court, in its judgment, was very clear right at the beginning to point out what the case was not. The case was not an inquest into the deaths of Mr. Gibson or Mr. Harris. And interestingly for us, the court mentioned the forthcoming public inquiry, and it said this judgment is not part of the inquiry, which is an obvious thing to say, but was very helpful, I think, because the judgment, in the way that it was framed and in light of judicial reviews being very specific and narrow and difficult, is indeed, or was indeed, much narrower than the inquiry will be. And the court noted that the draft terms of reference include, as you all know, looking at what happened in care homes and other social care settings, and the subjects of those settings include infection prevention and control, how residents were transferred into care homes and out of care homes, what happened to them when they were in a care home, what about visiting restrictions, and changes to inspections. So we all will be discussing all of this in much greater detail over the next few weeks and months. But I thought it was very interesting that the High Court referenced the terms of reference of the public inquiry in its judgment. The court analysed 4 policy documents that were issued in the early and mid part of 2020. I just want to talk very briefly about 2 of them, which I'm calling document 1 and document 3. I'm skipping documents 2 and 4 simply for time reasons. Document 1 was guidance that was issued on the 13th of March and sort of expired on the 6th of April, where the government advised care homes to review their visiting policy by asking no one to visit who's had suspected COVID-19 or is generally unwell. And they also emphasized good hygiene for visitors. Remember, good hand hygiene. Remember that in the early part of the pandemic, for some reason, even though it was known that it was a respiratory disease, there was a huge emphasis on washing hands. The government said contractors on site should be kept to a minimum, and care homes should also consider the well-being of residents and the positive impact on seeing friends and family. And the court also looked at document 3, or policy document 3, which I was writing about at the time. And this was a detailed document about the circumstances in which people could be admitted to care homes. And it said in terms, and this was on the 2nd of April, that negative tests are not required before discharging someone from an NHS bed in a hospital into a care home. It also said that care was to be provided in the normal fashion to asymptomatic individuals in care homes, and those who had tested positive but were no longer showing symptoms. And it said that staff only needed to wear PPE when caring for residents with symptoms. Remember, this was published on the 2nd of April. And the judgment spent several pages going through the chronology of what was known in terms of epidemiology at the time. And so just early on in March, I mean, I won't read all of this out, you can read it for yourselves, but there was evidence a month before that document was published on the 2nd of April about asymptomatic transmission or pre-symptomatic transition occurring. And on the 8th of March, 3 scientific papers were published, all of which suggested asymptomatic transition. On the 9th of March, the health minister in the House of Lords said, this is at the bottom, large numbers of people are infectious or infected, but are completely asymptomatic and never go near a test kit. So that's what the government themselves said several weeks before the 2nd of April document was published. And on the 18th of March, there was a very interesting paper published in the US by the CDC, the Center for Disease Control, on care homes in the US. And the paper identified factors that were likely to contribute to the vulnerability of people in care facilities. And you can see that they identified 5 factors. 1, staff members who were working while they were symptomatic of COVID-19. Number 2, staff members who worked in more than one facility, in more than one care home. Number 3, inadequate familiarity, and this will ring a bell, I think, for many of you who had or indeed have relatives or loved ones in care homes, the kind of lack of preparedness of the staff on the ground to what they should do. Precautions, eye protection recommendations, which is something that I want to raise with this group in a different setting, because I did some analysis looking at what the UK PPE recommendations were compared with the WHO recommendations, and eye protection is one of the things that was missing at the time from the UK recommendations. Anyway, number 4, challenges in the supply chain of PPE and other things like hand sanitizers, and then the number 5 is sort of the delay, because of the difficulty of figuring out who had COVID-19, the low index of suspicion, limited availability of testing, and the fact that the signs and symptoms were such that it was really difficult to figure out whether someone had just an ordinary cold or flu or COVID, or whatever it was. So the judgment set out, and it went beyond 18th of March, but for the purposes of this seminar, I thought that's enough to give you a flavour of what was known, which won't come to any surprise to those listening in. But the government maintained its stance that when it issued the policy guidance, it was not as well established in the literature that someone could catch COVID-19 through someone else who was asymptomatic. But actually, there is quite a lot of evidence to say that this is very likely. So what was the claim about? We've already touched on this. So early on in the proceedings, before the sort of final hearing, if you like, a previous judge had said that this is a case, it's a test case, it's of public interest, and it's about the legal duties of government towards a particular vulnerable sector of society in the context of a pandemic, under the European Convention on Human Rights, general public or equality law, and that judge said the proceedings raise issues of law of real and general importance. So it set it up to be a sort of very important case, and indeed it is incredibly important for those of us who have been monitoring what's happened in the social care system throughout the pandemic. The claimants said to the court that their father's Article 2 rights were breached. Article 2 of the European Convention on Human Rights, as is well known, sets out the right to life. And under the convention, governments have to actively take steps. So they have to be proactive in terms of protecting life and preventing death, as well as obviously not deliberately killing people. And the claimant said that the system's duty, which we can get into at another time, I think, required the defendants, i.e. the Secretary of State, to put in place laws and operational frameworks to protect against the risk of life. And then the second bit of Article 2, the operational duty, required the state to take practical steps to safeguard people's right to life from particular dangers where there's a link to the state's responsibility. So that's what the claimant said. And they also said that the common law duty of making decisions reasonably and rationally were breached, such that the decisions to allow people to be transferred into care homes and really do nothing to protect existing care home residents from asymptomatic transmission of COVID was unlawful. And so what did the court say? What was their decision? So on Article 2, there's a bit of bad news for us, I'm afraid, and I know that Cathy's going to pick up on this. It said that sort of get real about the system's duty. There was no arguable case that the system's duty had been breached. And on the operational duty, essentially, I'm not going to read all of that paragraph, but it said that because there's no case law by the European Court of Human Rights, that's what it means by Strasbourg jurisprudence, the UK courts shouldn't sort of leapfrog the Strasbourg jurisprudence, run past it and disappear into the distance. And the court found that the government didn't owe an Article 2 operational duty, which was argued by the claimants. So the claimants lost on Article 2, and also Article 8 of the convention was sort of dealt with very rapidly, and the court just said, look, that just doesn't add anything at all. And so if your claim really is in Article 2 territory, you can't sort of plead it again in Article 8. It doesn't make any sense. So that is slightly problematic for us in the inquiry. But what was more positive was that the claimants won under common law. And the court said that there was no scientific proof in mid-March 2020 that asymptomatic transmission was occurring, which is what the defendant government was saying. But the court said it was well recognized that by the experts that such transmission was possible. The court said that the growing appreciation that asymptomatic transmission was a real possibility ought to have prompted a change in government policy concerning care homes earlier than it did. There was nothing unlawful in the policy on discharge from NHS hospitals contained in the documents of mid-March. And the suggestion that the government should have made provision in March for the testing of each patient before discharge from a hospital into a care home is hopeless, because it went on to say, because there was such limited availability in terms of numbers of testing kits available. However, focusing on the document that I've already flagged, the 2nd of April document, which said in terms negative tests are not required prior to transfers/admissions into the care home, the court found that although there had been growing awareness of the risk of asymptomatic transmission, there's no evidence that Matt Hancock or anyone advising him addressed the issue of the risk to care home residents of asymptomatic transmission. I mean, just pausing there, no evidence that Hancock or anyone advising him took into account asymptomatic transmission. And the court went on to say the policy needn't have been black or white. So it didn't need to say everyone who goes to a care home needs to be isolated in their room for 14 days. The court said that it could have been more nuanced than that. For example, the policy could have said that where an asymptomatic patient, other than someone who has a negative test, is admitted to a care home, they should, so far as practicable, be kept apart from other residents for up to 14 days. But of course, as we know, the policy did not say that. And the court said that those drafting the March policy and that 2nd of April guidance simply failed to take into account the highly relevant consideration of the risk to elderly and vulnerable residents from asymptomatic transmission. And the decision to issue that guidance on the 2nd of April in that form was irrational, in that it failed to take into account the risk of asymptomatic transmission and failed to make an assessment of the balance of risks. So that's a really strong ruling. And the court said that the schema was therefore unlawful. So what are the implications for the inquiry? These are thoughts, and very happy to discuss them, and others may disagree with them, and it would be good to have a discussion as we prepare for the inquiry. This is not the only time and place that we will have this discussion, obviously. So just to throw some thoughts out there. So I think it was very helpful that the court set out in quite some detail a timeline, a sort of chronology of the policies and what was known at each stage about asymptomatic transmission. What it didn't do, I think, and I think that we as a team can add value to the inquiry, is look at the compatibility of UK guidance with international guidance, and, which I haven't put in the bullet point, is do some comparative analysis about what other countries were doing, other similarly situated countries, and what their policies were. What the court, the third bullet point there, the other thing which I think was missing from the judgment, when I say missing, it wasn't in the judgment. I'm not saying it should have been in the judgment, but could be in the inquiry, is policy documents, recommendations, guidance from international human rights bodies, by which I mean Council of Europe bodies, as well as United Nations bodies. And for those who are interested in that, I published a paper at the end of 2020 looking at what international human rights bodies had said about the rights of disabled people, so including people in care homes, and I'm very happy to send that to anyone who would like that. So I think that Article 2 is clearly problematic, and we'll have to discuss that further. But bear in mind that the judgment is not some sort of dress rehearsal for the inquiry. It was taken by two claimants. It was a judicial review which had a narrow focus, and the public inquiry will have a much broader focus. So we shouldn't feel restricted or confined by the issues that were raised by the parties, or indeed by the court in the case, or indeed the court's decision. So thank you very much. That's all I wanted to say at this stage.
Great, thanks very much for that, Oliver. Let me just sort myself out of this end. Great, so Cathy, we've got a few questions coming in, which, as I said to everybody, we're not planning to take in this session, but we will definitely be answering them later. I'd now like to invite you, Cathy, to come and join in, please. I think you're unmuted yet. So let's hear what you've got to say.
Yes, thank you for allowing me to participate. I was obviously extremely pleased that we did win at least part of this case. It was a long slog. It was a very complicated case. Yes, the case was complicated. We were trying to make a lot of points about how many things the government failed to do and exactly what went wrong. It focused down very much on asymptomatic transmission, which the government then denied knowing anything about, despite the fact that it was plain that they knew all along about it. And the risk, scientifically, the risk of asymptomatic transmission should have been considered anyway, because it's not uncommon. But there are other important factors that we didn't get anywhere near in this case. The law is a difficult thing to use. It's a bit of a blunt instrument, I think, trying to examine this. For a start, from my perspective, patients were transferred from hospitals with COVID. People who had tested positive were transferred. We didn't get anywhere near that. We didn't get much evidence. The defendants simply refused to provide evidence. It was extremely frustrating. We appealed to the court, asked a judge to rule that they had to deliver the evidence, this duty of candor. They just didn't do it. We got very little. However, one piece of evidence we did get, which was really shocking, was a senior NHS nurse, a message from a senior NHS nurse to Public Health England, saying that Public Health England really shouldn't warn care homes about the risk of accepting patients because they might put them off taking people in. Now that's really horrific, because not only do we know that this decision to discharge people from hospitals without any consideration for what was going to happen in care homes, the decision was deliberate, and they clearly knew there was a risk, which to me says it's always been about manslaughter fundamentally, but I can't go anywhere with that. It was a deliberate decision, and I always wanted to know why the decision was taken. And I maintain it was about freeing up hospital beds in a panic. And the only beds they could easily identify to use were those in care homes. We were all sitting at home keeping ourselves safe. Nobody said to me, you've got to take somebody from hospital into your spare room. We were told to isolate ourselves at home. But my father, in a care home, his beds in neighbouring rooms were just open to anybody. And that was really, really wrong. And the reasons they did that, they knew all along. Cygnus looked at care homes. They looked at the risks to people in care homes of an infectious disease. They already knew they should take particular care to protect care homes. They did nothing. And because we couldn't go on the human rights issue, the court said that if it would be too onerous on a government to have to protect so many people, which to me is a nonsense. You should be protecting enormous swathes of your population from a risk. But apparently that we just weren't allowed to go there with the right to life. But basically our relatives and care home workers were thrown under a bus to free up beds in the NHS. And I think that was politics. So exploration of the other failures has to come through the public inquiry. The failure to deliver PPE. Care homes had to give up PPE to the NHS. They didn't get the PPE they needed. They didn't get any guidance about how to protect care home residents right at the beginning, even though that was already laid out in Cygnus and other exercises by the government. And the fact that there was a deliberate decision taken to use any beds available in care homes rather than exploring any other route. They could have discharged people into community hospitals. They could have discharged them into separate units. There's all kinds of things they could have done. Testing wasn't that widely available. There was some spare capacity, but they didn't use it. So yeah, there are a lot of avenues still to explore for the public inquiry, but at least we got the fact that discharging people was unlawful and irrational because of the risk of asymptomatic transmission, which they definitely knew about early on. Thank you.
Brilliant, thanks. Can you all hear me again now? I do apologise for that, Cathy. Sorry, I had to drop out there. Okay, fantastic. Thank you for that. We have had a few questions come in, but what I want to do now is move on to the second part of the webinar, if I can, and the listening project. So, Elkan and Pete, can I ask you to offer your insight into the listening project, please? I guess starting with a bit of a rundown on what the listening project actually is.
Yeah, I'll pass over to Pete in a second, but can I just, while I have the mic, mention 2 points? Oliver, you mentioned the US survey, and interestingly, Governor Cuomo in New York State was, it seems, doing something very similar to what was done in the UK, hiding the statistics as well about care home deaths while he was transferring people into care home who was symptomatic and spreading the virus. And Cathy, you made the interesting point about, I think the court judgment referred to limited disclosure by the defendant. I think that was quite a polite term given what happened. And you also mentioned the duty of candor, which will apply in the inquiry, but it's a worrying sign that the court in judicial review proceedings allowed the defendants to get away with non-disclosure, because I think that's what it was. So we'll certainly be challenging that in the inquiry. Moving on, yeah, Pete has circulated an advice on memorials and the listening project, which I hope everyone has seen, but if you could just run through it, Pete. We're very interested in the response of the families and of people who are on this webinar to the suggestions that are being made and to the thoughts of the inquiry itself on having a listening project. So over to you, Pete.
Thanks very much. Just before I do that, can I say well done, Oliver, and thank you very much, Dr. Gardner, for what you've said. And just adding a couple of my own comments, that the Article 2 point sounds very legalistic, but it is actually quite important. But everyone can rest assured that so far as we need to, we will be re-arguing that. The arguments that the court accepted were ones which were put up in the correspondence about our own judicial review about getting a public inquiry. So it's a bit frustrating that the court has accepted those, and it is unhelpful, but it won't stop us. So don't worry too much about that, although it is problematic. The other point is that Oliver raised the international perspective, and this is something which I completely agree is very important. And along the way, many people we've already spoken to, we've spoken to people from Independent Sage, And one of the professors we've been speaking to is in fact a professor of, I think, comparative international public health. And so we will either be putting him forward as an expert to the inquiry or using him ourselves as somebody to help us in putting forward the evidence about the international perspective. Okay, Elkan's already mentioned the advice. This is such an important issue that we've reduced our advice to writing. And I think it's been emailed out and it's been put on the BJC website, and I think it's on the COVID Bereaved Families for Justice Facebook page as well. But don't worry if you've not managed to read it yet. Just if you haven't got access to it, just email Elkan and we'll send it out to you. But it is important, and it's an explanation of what we're talking about. At inquests and public inquiries into disasters or incidents which have resulted in multiple deaths, the process, of course, investigates the circumstance of the deaths. And this inquiry should therefore call family members to give evidence related to those issues which are set out in the terms of reference. So, for example, Lady Hallett has agreed with us that the 111 and 999 services should be part of the inquiry, and that family evidence relating to the response to calls will be vital to looking into those issues in just the same way as family evidence relating to the issues around care homes and hospitals is as well. But also, apart from that family evidence, inquiries have developed a separate and distinct practice in modern times, which is the hearing of material relevant to the lives of those who've died. And this is plainly very important to you, the bereaved, to recognise those who've been lost to the pandemic, or perhaps more particularly to the failures to prepare and respond to it. But it's also very important to the process as it concentrates the minds of the chair, any panel, the inquiry team, and other core participants on what the inquiry is really all about. And yes, of course, it's about policy and this and that, but ultimately it's about the loss of your loved ones. Now, Lady Hallett and her team keep mentioning this term, the listening project, but they have not so far spelled out what that means, despite our asking them about it. And we need to make sure that your wishes are fully taken into account, and that the inquiry doesn't just sideline or frankly patronize you through this so-called listening project. And so that's really why at this early stage we've circulated the advice. Now, we would like some feedback, not necessarily tonight, but soon, because we want to draft a proposal in accordance with your views as to what this should entail. But in essence, our suggestion is that we ask the inquiry to provide us with the resources to assist anyone who wants to prepare a pen portrait of the life of their loved one. This can be, for example, a statement in writing, it can be a short video, and it can include whatever you want about them and what they did, their loves and their achievements and who they were in life. It'll be purely voluntary. The products will be presented to Lady Hallett, and we'd ask her to publish all those pen portraits of families who wanted that on the inquiry website, and for a number of the pen portraits to be actually heard in hearings, either at the start of the whole process, which is the usual approach, or at the start and the end of each of the modules of the inquiry, because the inquiry is likely to occur through a number of different modules. And obviously the selection of pen portraits would be something we'd have to consider very carefully with you so as to ensure fairness. Now, if that makes sense, that covers the first part of the proposals, the memorials to each of your loved ones who died, and so far as you want to do so. And of course, let me reiterate, it would be entirely voluntary and there'd be no pressure on anybody either way. But the second part is the evidence relating to the circumstances of the death of your loved ones, and of course the effect of bereavement on you. And similarly, we would like to propose to Lady Hallett that we'll take statements from all who want to give statements to the inquiry, again, purely voluntarily. And the statements would be separate and additional to the pen portraits, and they would deal with the circumstances themselves. And again, these would be produced to Lady Hallett, and we would again invite her to publish all of those who wanted them published, and we would discuss with her team those which should be again heard in the hearings themselves. So the takeaways from me here are, please have a look at the advice that we circulated, dated I think the 29th of May. Ask us any questions you're unclear about and give us feedback about what you think about those ideas so we can formulate an actual proposal. And so just to reiterate that before I stop talking, the proposal, so far as we've crafted it so far, would have two strands. It would have pen portraits, sometimes called memorials. They deal with the lives of your loved ones. And they are, and then separately statements relating to the circumstances of death and the effect on you, the bereaved families. Now we have to accept, of course, that not all of the pen portraits and not all of the statements will be able to be part of the actual hearings because of the sheer numbers. However, the proposal would get as close as possible, I think, to giving everyone who wants to take the opportunity to actually have that opportunity to provide these two important elements of evidence, have it published, and to get as much of the family's evidence into the inquiry to assist Lady Hallett to come to conclusions about what actually happened. And what we fear is that if we don't put a proposal forward relatively quickly, is that the listening project will become a rather vague and nebulous process outside of the inquiry, and it will become marginalised. And so if Lady Hallett really means what she says, and of course we hope that she does, concerning putting the families front and central to the inquiry, she will see such a proposal as sensible and helpful. We're not reinventing the wheel here, I stress. These are processes which have taken place in a variety of other large inquiries and inquests, including Hillsborough, Grenfell, the Arena. Obviously, there are challenges due to the scale here, but what we don't want is for that to defeat the principle and to remove those opportunities from you. So I think that's all I'd like to say at the moment. I don't know, Elkan, whether you want to add to that.
Yeah, there have been a few comments in the chat from people saying that they're happy to provide evidence, or rather a statement for a pen portrait. And that's great, but what we want you to think about and discuss with us is how you would like that to be, first of all, taken, and then how you'd like it to be preserved. What we are nervous about, and Peter's mentioned this, is that the inquiry will set up a sort of, I don't know what you'd call it, but a sort of drop facility where people can talk to a software program and have their statement recorded, and it's just put to one side and doesn't become an essential part of the inquiry. We're anxious to ensure that it becomes an essential part of the inquiry, and that the chair in particular hears it and pays attention to it. So we're thinking about how that can be done, but we'd be very grateful for help from you as well as to your thoughts as to how it can best be done.
Okay, how would you want those thoughts sending to you, Elkan, in the chat on here?
Yeah, chat here, emails to me, telephone calls to our COVID line, however people want to get in touch.
Right.
And Nicola's just put up a general email, COVID inquiry email.
Yeah, a COVID inquiry email's just gone on the chat, everybody, if you want to go in through that. Okay, great. Are you and Pete done on the listening project at that point then, Elkan?
Yeah, can I just add that comments, but also questions. If there's anything I've said or anything from the advice that you don't understand, then ask questions, and we'll try to address any individual questions as well.
Okay, well, we've finished sort of 10 minutes before I'd normally wind up. So Elkan, I've got a few questions that I've picked out of the Q&A here. I know I said we weren't going to answer any live questions. Would you and the panel be up for answering a couple of questions that I've seen come up in the Q&A, and you too, Oliver?
Yeah.
Yeah, fantastic. Well, let me start off with Oliver then, seeing as he went first. Oliver, what about the staff who died in care homes? How will this case impact the staff in care homes who died because the NHS discharged infected patients back into the staff's working environment, ultimately leading to the staff in the care homes becoming infected, and some of those obviously died?
Yeah, absolutely. I suspect that there will be representation of staff in care homes who died in the inquiry. So whether that will be through care home staff associations or trade unions specifically, or generic trade unions such as Unison and so on, I think we'll just have to see. But I'm sure that, or I'm very confident that the inquiry will look at that issue as well.
Okay. Thank you. Number two, so it's still with you, Oliver. Does the ruling also cover people sent home from hospital that had not been tested because they weren't being discharged into a care home? So does it also cover people who weren't going to a care home?
No, it just looks at the situation of people entering care homes.
Okay.
But again, the inquiry doesn't have to, and being care homes is one of the myriad of locations and topics that the inquiry will look at, but people's homes is also another location, people's workplaces, and there are other social care locations that people live in, such as supported accommodation, which was rather neglected throughout the whole pandemic, and some supported living placements can be very similar to care homes. Yeah, I hope that helps.
Okay. Number three, I think this might be Oliver, might be Pete. Has there been any consideration of the competence, training and supervision, sorry. Has there been any consideration of the competence, training and supervision of care staff with regard to PPE and working in a care home environment where COVID had been infected? So was that competence and training included in the Gardner case, or would that be one for the wider inquiry?
The Gardner case was really looking at the policy documents. So it was a sort of paper-based exercise, if you will, but certainly competence and preparedness across all of the different sectors is going to feature in the inquiry. And I know that many people have been highly critical of the government in terms of preparing care homes, but also we shouldn't forget that 97% of care homes are non-governmental, right? They're owned by private companies or charities or religious organizations, and they too have responsibilities. So I hope that the inquiry will look at the sector's responsibility to prepare themselves for epidemics and pandemics as well. But competence on using PPE, we knew right back when it was all happening. I mean, you just had to watch TV and you had care home managers saying, we don't know what to do. We're wearing bin bags. We've received no training on any of this stuff. And I didn't see any kind of rapid rollout of training, even online training. But I'm sure that there'll be lots of evidence from the care home sector themselves about that issue.
Okay, thanks. Two more for you. One's a check, actually. Someone's asked, so the whole Human Rights Act side of the case was more or less dismissed out of hand. Is that pretty much what you were saying?
No, I wouldn't say dismissed out of hand. It was very carefully considered by the courts, and they ruled against it. They didn't just flush it away without considering it. It was a carefully crafted decision, but ultimately unsuccessful.
Okay. And then finally, for you, Oliver, would some of these issues also apply to hospital settings as well as care home settings during that period?
Yeah, absolutely. The case didn't look at that because it was outside the remit of the case. Again, hospitals will definitely form part of the inquiry, and the same issues arise in hospitals. I mean, we know that thousands upon thousands of people caught COVID-19 in hospital, and I know from my brother's an NHS doctor, and so is his wife. And it was all, I was going to say something very rude, but it was all quite chaotic. And they couldn't get access to tests for people who had COVID symptoms. People were still sharing rooms, etc., etc. So yes, the healthcare system is going to be for sure under the spotlight, but you won't find anything about that in the case, in the judgment that we were talking about.
Okay, thank you very much.
Can I just pick up on the human rights thing, because it is creating some heat in the chat. Reduced to simplest terms, Article 2 and the case law across Europe requires all states, including the UK, to identify threats to life and to do everything reasonably possible to effectively minimize and mitigate those threats. And the courts, encouraged by the government lawyers, seem to have adopted a position that because this is such a widespread, apparently naturally occurring virus, that Article 2 doesn't apply. Now, Cathy, Dr. Gardner earlier mentioned that her being perplexed at the fact that the court seemed to think that the more deaths there were, the less application the Human Rights Act had. And she, with respect, is absolutely bang on with that. And that's something which I don't follow, and I will absolutely argue or re-argue, or whatever the right thing is, if it becomes necessary. Now, it may not become necessary. Lady Hallett may have a view on it, or it may be that she fudges it and decides she doesn't need to determine the applicability of Article 2. We'll cross that bridge when we come to it, but it is something which the team is very on. It's always been on it. We were, in fact, aware of the arguments that were put forward by the government in the correspondence we had earlier. So that's really what it's about.
Okay, thanks, Pete. Elkan and Pete, these ones are for you, I think. This is quite a good one. If the government was reluctant to deliver evidence to the Gardner case, may they do a similar thing in the inquiry? And if they do that, is there any other way of the inquiry accessing the evidence that they might want to try and dodge?
No, I think it'd be very, very difficult indeed for the government to avoid, or anybody else really, to avoid producing relevant documents to the inquiry. I think the problem for the inquiry might be the other side, is determining what to require from the government. I mean, I just think the massive material that is relevant to this inquiry is so huge that to avoid having to look for needles in haystacks, then there'll have to be a sort of smart approach to it, and we will help with that. Some of the lawyers involved in our team have been arguing about the duty of candour since it was invented. And we've been pressing since the Hillsborough case for a statutory duty of candour. So we're all over this. We will definitely be putting forward proposals to the inquiry about how they should target their requests for production of documents. Elkan, from the beginning of the whole process, has been calling on government and since Lady Hallett was appointed, Lady Hallett, to do everything possible to stop the destruction of documents or the losing of documents. Now, obviously we can't completely stop that from happening, but I think we've minimized that. So yeah, the duty of candour is vital here, but the public inquiry has a lot of tools at its disposal to ensure that that disclosure is full, and we will constantly argue that until we get the full 9 yards.
Okay. One last one for you, Elkan. Do you have a deadline in mind for feedback to come through to you before you approach the chair with your recommendations for the listening project?
I think ideally the next week or two. I know that's asking for a quick response, but our worry is that they will dream up their own scheme, and then it becomes much more difficult to persuade them to alter it. Okay,
fantastic. So Oliver, Pete, Elkan, anything you want to say before I wind up? We've only got 2 minutes to go. Anything we've missed? Anything you want to say in the last minute or so before I wind up?
I just want to say...
Sorry, Oliver, go on.
I'm so sorry, I didn't want to cut across.
You go first, Oliver.
Okay, I just want to say that I'm very happy to, because I know that a lot of people here listening in are concerned about social care and healthcare, and I'm very happy to organise other webinars where we can look at the substance. You know, what did the policy say? What was required in terms of PPE, and compare it with what was happening internationally. I've written quite a lot about this, so very happy to organise further, webinars as we get closer to the inquiry starting, just so that we're on the same page and we can listen to you about your concerns more broadly. So I just wanted to.
Brilliant, thank you. I'll come to that at the very end then, Oliver. No worries. Elkan, what were you going to say?
Yeah, two things. One is just to echo the thanks that people have been giving to Cathy. It's not an easy job being a litigant in court proceedings, whatever proceedings they are. It's really emotionally draining. So well done, and successful as well, even better. The second point was, I'm thinking what we'll probably do as time goes on during the summer is have a series of very short videos, maybe 3 to 5 minutes, on particular issues that we think people might be interested in. So if there's a particular general issue you'd like a sort of guidance by way of video on, or a dummy's guide to something, let us know and we'll come up with something.
Yeah, that's a good idea. Get those videos on big issues is a good idea. Okay, we're all done, panel. Yeah, great. Look, before I wind up then, just want to say thanks so much to you, Dr. Gardner, to Cathy. Thanks for coming in. Thanks very much as ever to all our panelists, Oliver, Pete, Elkan. That was really, really good. I know I could see in the chat there's a lot of thumbs up for this, and people are really appreciating this. So just leaves me to wind up. Thanks to all the panelists for coming. Don't forget, a recording of tonight's session will be sent to Brody Jackson Cantor clients. If you've asked a question in the Q&A, you will receive a personal answer. And if your question is of general relevance, that will be added to our general Q&As that you can find on the Brody Jackson Cantor site. So do, as I said at the beginning, have a look at those. And very lastly, you will be sent a questionnaire when this session finishes. So we'd be really grateful if you can fill that in. And to Oliver's point, if there's anything that you'd like to hear more about, then that's your opportunity. Apart from if you put it in the chat, we do go through the entire chat and the entire Q&A when we finish this. A team of our lawyers goes through that to pick out everything to make sure we're answering. So if you haven't got it in the Q&A or the chat, then by all means do put that in, and we really would like your feedback. We do try and make these things interesting and keep them lively and keep it really accessible for you guys. So yeah, please do fill out our questionnaire at the end. And that's it really. Thanks very much, everybody. I'm going to wind it up now, bang on 7 o'clock. So well done, we've hit the hour, and we'll look forward to seeing you in the next session. Thanks very much.